guess we're going to move on to licensing directly.
Yeah, so just have to say a few words on that. I just taking a look at the history of the securities markets, and I found out that the first licensing requirement was done in the 13th century by King Edward in London. And then thereafter, we have seen in the late 1800s and the early 1900s some movement toward regulations in certain states in the United States. And they were not complete, they were not adopted by everyone until the 1929 big depression that ensued the 1933 Act under the Securities and Exchange Commission. But since then, we have seen every once in a while, every few years, we have seen some kind of a crash or some kind of a market disturbance. I'm sorry, it's on. Wait a minute. Better now? Okay, sorry. Okay, so since the 1929 depression, we had seen the 1987, close to the same depression, and then we witnessed 2007, 2008. So this brief history proves that regulation need not be always a reaction to a disastrous situation. It needs to be rather preventive in order to minimize systemic risk and provide the necessary protection of the market. The global financial crisis in 2008 put in question the reliability of the so-called dispersed or decentralized financial system, as well as the benefits of deregulation. And that's what His Excellency talked about this morning in regathering the control over the market in one stream and in cooperative way. Regulators from around the world gathered again to reinstall sufficient and effective regulations to ensure the necessary protection of the global system against future shocks. The big questions facing regulators is what approach should they adopt in this process of regulating the market without jeopardizing economic growth. We have opted to enforce regulation but not to force it. In that sense, we have endeavored at creating a full partnership between the regulator and the business community. By doing so, all regulations are discussed and agreed upon between the two parties before being enacted officially. Ample time is given for implementation, taking into account the costs related. In our newly established CMA, we are giving priority to this partnership through a process of education, dialogue, and reform necessary to help develop healthy and efficient market through the modernization of certain legislations existing now in Lebanon. And with this, I would leave the floor now to the experts to present the first regulation on licensing and registration. And then thereafter, we will take questions and we'll open the floor for you to participate. Thank you.
Okay, so we're going to talk first about licensing and registration. Halil and I will present basically an overview of the requirements, fairly high level, and then we're going to open the floor to questions and comments that will be taken by the three of us on the technical panel up here. So if you think of a question or have a comment, please bear with us until we get to the end of the summary. The agenda is, well, I'll quickly outline the purpose of this regulation. We'll talk about the definition of securities business, what needs to be licensed, the licensing requirements, briefly talk about process, and then Halil will take you through the requirements for persons who perform functions in institutions that require registration with the authority and how that application process works. So I'm going to skim through this. You basically know most of the background, but the bottom line of this regulation is that all persons that carry on securities business, as we're calling it in this regulation, need to be licensed by the CMA. And those institutions are called approved institutions in these regulations. And the reason for licensing is not simply to ensure that a firm is qualified and appropriate to carry on this type of business for clients. It's also, a key aspect of licensing is this is the nexus, this is the relationship between the regulator and the persons who are regulated in the business. It defines, in fact, who is regulated. Without licensing, you're not really regulated. Only the current intermediaries, banks, financial institutions, and, if you will, brokers can be approved institutions under this draft regulation. Now, although they're licensed, of course, the authority is only regulating, in the case of banks and financial institutions, the securities business. Obviously, these institutions remain completely under the authority of the central bank for purposes of all forms of banking business. So, all of the institutions are approved by the CMA only for the purpose of their capital markets activities. And what are those supervision tools? Well, they're the ones that you'd be familiar with. Regular reporting to the regulator, to the CMA, periodic inspections of your capital markets operations on site at the firm, market surveillance, and handling of complaints to a large degree. What is the purpose of this reg? As I said, it defines the types of business that require a license. It sets out a few really very limited exemptions from the licensing requirement. I mean, the definition of business implies and requires that you're carrying out a commercial purpose, for example. It establishes the categories of license. There are 5 of them. I'll take you through those in a minute. It sets out the basic requirements and the approval process to be followed by the authority. Similarly, it defines those functions that require registration and sets out those registration requirements. So the bottom line here is that only approved institutions are allowed to carry on or, in fact, to market securities business. So there are some rules on so-called securities advertisements, and that can mean a general advertisement or marketing push to the public, or it can mean a one-on-one promotion to a potential client. In either case, you can't do that type of marketing unless you're in fact licensed to do securities business. The 5 types of activities that constitute securities business are the same ones that you see in Saudi, which in fact were originally taken from the UK. At that time, they were the FSA regulations. That institution no longer exists in the UK, but that is the origin of these 5 categories of license, which you also see in some areas, other areas of the Middle East. What do we mean by these terms? Dealing. Dealing is really any form of trading in securities, whether it be for clients or for a firm's own account, for its proprietary or prop account, including, for example, market maker or liquidity provision activities, or distributing securities, distributing new issues of securities. Advising is any form of investment advice or any form of advice on any kind of capital markets activity, such as financings, new issues of securities, investment banking operations, for M&A, for example, and so on. So advising is, very simply put, the giving of advice in securities business activities. Arranging is something that we often have a bit of a hard time getting a handle on because it's kind of related to advising, but it doesn't actually require that any advice be given. The key to understanding arranging is it's bringing parties together to do transactions or securities business. It's basically matchmaking, if you will, or introducing persons to deals or transactions. And the idea is that you shouldn't really be bringing people together to do securities deals or transactions unless you're licensed and qualified to do so. And that includes arranging corporate finance type business. Managing, naturally enough, management of investments in any form, including for an individual person or for a group of persons through an investment fund or a collective investment scheme, including discretionary portfolio management for an investor. Those are all different forms of managing. And then finally, we have custody, a type of license that will probably not be sought by a large number of institutions, but that, of course, is the safeguarding of securities or assets of investors and arranging for the administration of those assets, for example, handling of corporate actions and that type of thing. So you need to obtain a license for each type of activity that is carried out. That's one license that can cover several types of activity depending on the nature of your business. The key principles that apply to an applicant for licensing are listed here on the screen. And these are really the core requirements to be licensed initially, but they are also the key principles that apply on an ongoing basis to institutions carrying on securities business. You have to continue to be seen to observe these things by the authority in order to remain a licensed institution. I think these are quite self-explanatory, and if there are questions, we can get to those at the end of the presentations. I'm only going to really expand on the first one, the fit and proper person principle. Fit and proper is a concept that we often see being applicable to individuals who seek registration, for example. But here we're talking about whether a firm, whether an institution itself is fit and proper to be in securities business. So what are the indicia? What are the factors that the authority is going to look at when they get an application? One is looking at the registered persons themselves that the firm proposes to have, the directors, the senior management, the key persons in the business. Are they in themselves fit and proper as individuals? That is definitively a key consideration. Also, they need to look at the controllers, those persons that control the institution, and any persons that are associated with the institution. We're referring to associated persons as persons with close links. That's the terminology that's being used. So, are they suitable? Have they got the requisite experience? Then the authority needs to take a view on whether it looks like the business and affairs of the applicant will be conducted and managed in a sound and prudent manner. Bit of a buzzword, but we all know what it means. And they also need to take a view on whether they believe that the applicant is going to be able to meet the requirements for approval on an ongoing basis. And that basically refers back to all of the regulations in the business conduct requirements, market conduct, and other regs that apply to an institution. The CMA has to have a level of confidence that this applicant can actually comply with those things on an ongoing basis, which is not a trust factor so much as it is an assessment of their personnel, infrastructure, policies and procedures, etc., that shows that demonstrates that they're capable of doing so. And finally, a catch-all under fit and proper. Basically, they can take into account anything that they believe is relevant to assessment of fitness and properness. I just want to make the comment before I hand it over to Halil that, as I said at the outset, these regulations are set up basically as principles to a large degree. They're not that granular, but the application of those principles that I just showed you on the previous slide, including fitness and properness, the application of those things will vary significantly depending on the nature of the applicant and what type of license it's applying for. So please don't assume that it's going to be a one-size-fits-all approach to reviewing applications. Not at all. I mean, first of all, the requirements to obtain a dealing or trading license will necessarily be quite different from those that would apply to an institution that only wants to do advising, for example, or only wants to do corporate finance transactions, because they don't need to have the same types of policies and procedures in place, and to a certain degree, the personnel needs to have different experience, and so on. Secondly, the size and scale of the business is very important. Again, it can't be one size fits all. What one would expect to see from an applicant that wants to carry on retail brokerage, basically, in a non-complex manner, and not launching a huge business that's akin to the securities business of one of the large banks here in Beirut, we wouldn't expect them, in reviewing an application, to have the same degree of complex policies and procedures in their various manuals, or to have the same level of infrastructure and, for example, risk management that you would expect a big institution with multiple forms of license to have. So this regime is designed to be accommodating to different types of securities business operators and applicants for license.
Thank you. Good morning. For those who don't know me, my name is Khalil Ghalayini, and I head the control unit at the CMA. I would like to take this opportunity to share with you what the control unit has been doing in the last year or so, just a brief couple of minutes. The unit is composed of 7 members so far only, and most of you probably have had the opportunity to engage with them directly or indirectly. We hope to grow the team quite drastically and very quickly, and we're quite selective in the process. Actually, we have, in case anybody is interested, some applications at the front. So that was the joke of the day. So that being said, the process that we use at the control unit in working closely with the legal department would be along the lines of providing recommendations to the board. And the recommendations range on different aspects, such as licensing application of new institutions, or sometimes relevant towards approving products. And when we talk about approving products, we do not base our recommendation on the merits that this is a good product, obviously, or a bad product. We analyze the documentation that's been provided to us significantly, as some of you may know by now. We look at the term sheet, we look at the offering circular, we make sure that they are clear, transparent, and include all the necessary information for an investor to be able to make an investment decision. The type of products that we have been dealing with recently range from common share offering, preferred share offering, mutual funds, structured product, securitization. We've conducted series of investigations that emanated from client complaints. We've conducted certain investigations based on certain trading activity on the BSE, our partners in this process as well. And we have conducted series of off-site and on-site audits, to name a few. That being said, I will cover today the licensing requirement and approval process for institutions and individuals. And I would like to go very quickly, like John did, on majority of the slide, to leave some ample time, especially towards the last section of the presentation before we take your feedback, which is quite important to us, relevant towards the registration or registered person and the registrable functions for different functions and the required exams that is required under the circular, BDL Circular 103, which I'm sure is quite dear to your heart. To apply for a license, an applicant must be established as a bank, financial institution, financial intermediary, or be a subsidiary of a financial institution that's been licensed by a foreign regulatory authority. An applicant for a license must specify each type of license that he is seeking approval for. Applicant should demonstrate it meets key principles, the fit and proper criteria, which John elaborated on a second ago, includes suitability of controllers, close links, and registered persons. And when we refer to controllers, these are persons that own 25% or more of voting shares, or they have the capability of appointing 25% or more to the board. When we talk or refer to close links, this is the relationship between an approved institution and a controller, or it could be the relationship between an approved institution and the company which the approved institution controls, or the relationship between an approved institution and a company which the controller controls. CMA applies principle based on each type of securities business you apply for within the 5 types that Mr. Gabriel and Mr. Carson referred to, and based on the scale and nature of the business. File all the required documents, operations manual, and information, and complies with the requirements in CMA business conduct regulation. Process and approval for new institutions. Apply to CMA, the slide says control unit, but actually it goes both for legal and the control unit, in prescribed form, which is Annex 1, which mainly covers the corporate resolution, the securities business profile, the business plan, the list of close links, the list of controllers, so on and so forth. Incomplete applications will be returned. The CMA may require further information to the application. The CMA has the power to approve the application, obviously, in whole or in part, or refuse it altogether, or impose certain limitations to it. Whatever the CMA's decision is going to be, the applicant will be receiving a written confirmation in writing on the decision. Approved institution must apply for approval of any changes in license, which requires CMA approval. And once again, the CMA may approve the application in whole or in part, or impose limitations. CMA must approve ceasing securities business or cancellation of a license, whereby the approved institution must notify the authority 60 days in advance. Approved institution must ensure that any outstanding business with clients has been attended to, and that all clients have been given a 30-day advance notice. Process and approval of existing institutions, which I'm sure is also important to the crowd in here today. The structure is going to be user-friendly. John at least promised that it's going to be the case. Streamlined filing and review process will apply to existing institutions. The existing institutions are going to be exempted from certain documentation and filings such as the financials, such as the business plan, such as the list of controllers, such as the list of close links. We're going to give you a clear list of the exempted items which existing approved institutions are not required to file with the CMA. So it's going to be a limited CMA review process. The key purposes for licensing are issuance of license in the 5 categories, and we've named the advisory, arranging, managing, custody, and dealing. Registration with CMA as an approved institution, and this is under the scope of the new business conduct regulation. Ensure compliance with new CMA regulation. Application process will be in stages, and we are hoping that it will be taking a window of 3 to 6 month period. Focus on filing of revised manual and procedures based on the new business conduct regulations and other regulations. Licensing application. As per Annex 1 and Exhibit 1, which I'm sure all of you received already, must be submitted both in hard and soft copy. Documents and information to be filed by new institutions include securities business profile, which includes the type of license to carry on securities business, corporate structure and organization chart, business plan, which includes the business strategy, IT strategy, capital structure, custody agreements, details of controllers and close links, financial statements, material contracts, terms of business and client agreements, operations manual, which includes procedures manual, reporting to client, and compliance with record keeping, which is something we're going to touch base on in tomorrow's workshop. Systems and controls documents. So once all these documents are received and reviewed by both the control unit and the legal department, and the recommendation is provided to the CMA, if the CMA's decision, the board's decision, is to approve an application, that's when an approval process is called a provisional approval will be given to the applicant, which entitles the applicant at that point in time to go and register the company and go set shop, whether it's the lease, whether it's interviewing people, getting his contract in order, getting his IT systems in place. And once they're ready, they notify the CMA, and in turn, we go and conduct a commencement audit just to make sure that the systems are in place, whether it is like recording calls, the infrastructure of Chinese wall are between certain departments to make sure that the corporate finance are isolated from the advisory section and the dealing room is isolated from all other departments and the risks, so on and so forth. Systems and controls. Documents and manuals to be filed by all applicants include financial controls, policies and procedures, risk management policies and systems, AML and anti-terrorism financing program and procedure, compliance manual, compliance monitoring program, code of conduct for directors, officers, and employees, as per Annex 1, manuals, policies, and procedures, which I'm sure most of the institutions that are licensed have them, but they need to be reviewed to make sure that they are within the new code of the business conduct regulation. Subsidiaries may use parents' manual if that manual meets the requirement of the business conduct regulation and that they actually met the approval of the CMA. Maintaining a license must continue to be fit and proper. So as you can see, the magic word of fit and proper is throughout the slides. Must continue to comply with all regulations and requirements, follow requirements for notifications to CMA, and that's within Annex 3. Annex 3 also covers material changes and events, including any changes in business, changes in controllers or persons or close links, must be approved by the CMA, and the CMA should be notified 30 days in advance. Obviously, this particular requirement is not applicable to banks that are licensed by BDL. Registered persons. So this is now the topic which is, I think, at least is quite essential, and once again, not because the others are not. When we looked at BDL Circular 103, we examined it quite closely, and we decided to dissect all the registrable functions that have exposure in any form towards securities business. And we were able to identify 45 of them. And then we started examining the records of, the exams that are required for those registrable functions within the same Circular 103. And we identified 9 of them. Just very briefly, to put it in context, because I'd like to compare the old regime versus where we're going with the new one. The list of exams currently required for those functions that are only exposed to financial securities are Lebanese financial regulation, global securities, risk in financial services, investment and risk, financial derivatives, scams, combating financial crime, international investment and wealth management, and international introduction to investments. So after we looked at those and dissected them as such, we wanted to get a clearer idea of the state of the union, if you may. And we decided to launch a survey to the market where we've sent templates out, which all institutions received. We made sure that we covered banks, financial institutions, and intermediaries. And it was pretty much the list of the registrable functions, the section that refers to that function within 103, the type of exam that is required, and the number of exams that are required. And we've cascaded this template, electronic and hard copy, and we received the data back, thank you. And after we amalgamized and populated the data in a master sheet, honestly, the picture was a bit complicated still, like it wasn't still clear to us as a regulator. So that being said, our objective is to simplify the system because the current one does not conform to international standards. Excuse me. CMA will replace BDL Circular 103 only for the securities side of the business. So anything under Circular 103 that is relevant to the banking sector is as is. So CMA will only be involved in looking at the applications of registered persons that conduct activities in the securities side of the business only. CMA will maintain register of registered persons, must be approved on a register to perform a function. Qualification examinations are being streamlined. Current registered persons who met the requirements under Circular 103 are grandfathered, but must be added to the CMA register, must be fit and proper as per Article 2406 of the new regulations. The authority will consider the applicant's skill, experience, adequate qualifications, and whether that candidate has ever been convicted in an offense or not. The power of the authority, where they may refuse an applicant, approve in full, or in part, or place limitations. I would like to walk you down the aisle of the new 10 registrable functions. So the first picture that we looked at is a 45 registrable functions that are going down to 10. And actually, if I want to oversimplify it, I can simply try to, I don't want to, let's call it grouping, the 1, 2, 3 in management, if you may. There's the finance officer, the supervisory aspect of a body that could capture pretty much 5, 6, and 7. And then you've got the senior manager of a department under 8, the client representative, and the traders. So the objective of the exercise is to simplify the manner for the institutions, for the candidates, in understanding clearly where he fits in these categories of registrable functions. And then we looked, as I said earlier, at the 9 exams that I covered, and we thought that it is prudent to reduce those exams from 9 to 4, keeping in mind that the first 2 exams, or actually 3, are exactly the same. So we even wanted to minimize the headache that we don't want the existing institutions to feel that here comes the new kid on the block, if you may, changing even the exams and even the venue. So everything is as is. So we're using ESA. The securities exam is exactly the same that people have sat for and passed at ESA, and the same thing for the derivatives, and the same thing for the AML people. The only course that we have added is the business conduct regulation, which is a very important course, but actually it's the one-on-one of the business, right? So I just want to use an example just to demonstrate to you how the new regime, if you may, is going to be different from, I'd like to think of it from a half full rather than a half empty approach. I looked at a certain job function, for example, which covers private banking, trading, and sales execution only advisory or discretionary basis. That particular function in the old regime required 6 exams of the 9. So under the new regime, the same position, which would be going under a client representative, would be required as in the suggested box, obviously. So you can see number 8 on the slide, requiring exam A, B, and D. So you went down from 6 to 3, keeping in mind that the individuals that already passed those requirements are grandfathered. Excuse me. The process and approval, file application, thank you, form with all required documents and information as per Annex 4. Application must be endorsed by the approved institution, meaning an applicant could not and will not be able to come and register with the CMA independently. So for him to conduct a certain registrable function, he should be working for an approved institution, and that approved institution obviously need to be licensed within the business that they are filing with the CMA. Applications must be endorsed by the approved institution, where they would review the fitness and properness. Incomplete application will be returned. CMA may require additional information. CMA may approve a candidate or impose certain limitations to the approval. The approved institution must notify the CMA if a person is no longer working in that registrable function, and if that person is terminated for cause, the CMA should be notified of that cause as well. So in a nutshell, if I want to sum it up, if you passed already the required courses under 103, the old regime of BDL, there's nothing to be done. You're grandfathered. If not, further exemptions will be, extensions. I should bite my tongue with the word exemptions. The extensions, if you remember, I just want to walk you through this for a minute, and then we'll open it up and give it back to Mr. Saliba. The courses required candidates to pass these exams with certain deadlines ranging from June 2012 initially, and all these exams were given another extension taking us towards end of 2014. So keep in mind that we're talking about exams that were introduced in the system back in 2006 with the deadline 2012 with an extension to 2014. And now here we're maintaining the same exams, the securities and derivatives. So for those that have not passed as of yet, we are open to think as to what will it take objectively to get these guys to the finish line. That's for those that have not passed yet. And for the exemption criteria, this is something we're still discussing, we're reviewing. Your feedback and input would be highly appreciated, because at the end of the day, it's very important for us not to be perceived by any stretch of the imagination that we're putting sticks in the wheels. On the contrary, we want to lubricate that wheel. But on the flip side of that coin, we want to make sure that the individuals that are working within that particular registrable functions have the fit and proper criteria to continue in that function. Thank you.